We say white, the defense says black. Our medical expert said the sun is up, their medical expert says the sun is down. How does the jury know who to believe? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. In every trial, in every case, whether it's an accident case or a medical malpractice case or a wrongful death case, there is a dispute. There is a dispute between two different sides. One side says one thing, another side says another thing. You did it? No, I didn't. You contributed? No, I didn't. There's always a legal dispute. So now each side brings in their own witnesses to support their claim, their side of the story. So now the jury is faced with listening to two totally opposing versions of what happened and who's responsible. How does the jury actually decide who to believe? The answer is simpler than you think. Let me give you a great example. Let's say you meet somebody for the very first time and you begin talking to them. Maybe it's at a party. And now, during the first few moments of talking to them, you form in your own mind an opinion about whether or not this person is credible, believable. Is what they are saying, does that make sense? So you know from your experience, from your life experience, whether or not you can immediately trust this person or whether you're on guard and you have to be careful what you say. Is this person trustworthy? Same thing at trial. The whole point of the trial is to establish credibility, to establish that what we are saying is more likely true than not true. And once we are able to show you that our version of the events are more likely true, now, at the end of the case, the judge will tell you that you have to evaluate credibility. And if you find that what we are claiming is more likely true than not true, then you must give us a verdict in our favor. How do you evaluate whether someone's telling the truth? You have to go back and use your own life's experiences. Are they contradicting what they said in pretrial testimony? Is there something that's just not believable about their story? Is there some testimony that an expert is giving to you that makes no sense whatsoever? Does what this witness say make sense? Is he believable? Is he not believable? Is he not credible? The judge will give an instruction to the jury at the very end of the case, and this is an important instruction. It's called falsus in uno. And that's a Latin term that says, basically, if you find that a witness has testified falsely about one thing, you can disregard all of their testimony should you choose to. And that could be devastating for whoever it is that you find against. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil lawsuits here in New York. You know, I recognize you've got questions or concerns about your own matter. Well, as long as your matter happened in New York and you're thinking about bringing a lawsuit and you've got questions, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, @oginski-law.com. That's it for today's video. I'm Jerry Oginski. Have a great day.